making that finding. I just don't think it is required by our statutes or the Uniform Superior Court rules.
I agree. In reviewing the pleadings, there was no special plea filed by the defense. However, the evaluation was done. That has been admitted. That has been reviewed by me. I will sign an order that finds the defendant is competent at this time and was indeed competent as well at the time of trial, based upon the report and the other matters that are of record that the court has participated in, including Mr. Ibarra.
Thank you, Your Honor. No objection.
All right. Does either side want to be heard about whether or not this evaluation should be placed under seal?
We would request it be placed under seal.
State have a position?
I won't oppose it, Your Honor, and defer to the court.
Okay. I will place that under seal, but it will be part of the record.
Thank you, Judge.
All right. Does that take us then to the amended motion?
To the amended motion for new trial, which you are ready. We do have one witness, Dr. Susan Ballard, who would be testifying via WebEx.
Okay.
Dr. Ruth Ballard. I apologize. Dr. Ruth Ballard.
That's all right. Do you want anything preliminarily before?
Preliminary for the court. We've raised 3 enumeration of errors. The first error was this honorable court's order denying a continuance violated Mr. Ibarra's 6th Amendment rights to counsel and his 14th Amendment right to due process. Enumeration 2 is the court's order denying a continuance constituted an abuse of discretion. And count 3, the court erred when it denied Mr. Ibarra's motion to suppress that was heard prior to trial on the cell phone evidence. Today we are just we have Dr. Ballard, who will be here to testify, and that her testimony goes to the first 2 enumerations of error. We're ready to proceed with testimony at this time.
All right. Anything from the state?
I do have some documents that I'd like to use to supplement the record as it pertains to enumeration of errors 1 and 2. I can do that when we're doing argument on the case because they are self-authenticating documents, or I could just do it now and then we'll take the testimony from Dr. Ballard and then we'll have argument. I'm assuming we're arguing after testimony.
We would be requesting a briefing schedule. What we would ask for is, after the transcript has been filed of Dr. Ballard's testimony, to have a briefing schedule so we could submit a written brief.
Okay, well, permitting your order on that, Judge, if I could then just go ahead so I don't forget, and it's just part of the record, should we brief it or argue it today, of the documents that I've shown to defense counsel, which states Exhibit 2 and 3. One's already been admitted.
No objection.
And for the record, State's Exhibit 2 is just a GDI record certification that shows how and when the raw data, in this case, was distributed to trial counsel and when they accessed said data. And then State's Exhibit 3 is just my letter dated September 17, 2024 to the GDI requesting the raw data on behalf of the defense. And I should note for the record that State's Exhibit 2 is a composite exhibit. It has 3 documents. And I hand it to the court.
That's fine. You put it in the court order.
Thank you.
Claims 2 and 3 are admitted. You want me to give him his Dr. Ballard?
Yes. Your Honor, would it be better for us to question her at table or use the podium?
That is good if you can do that, because there's a microphone there. I understand you might be using the podium for a display.
Yes. I can just go up there when I need to use it.
That sounds
It's only
fine.
one part
That
of
sounds
it, and it's
fine.
kind of, that would be fine.
Let's see. Dr. Ballard, can you hear?
I can.
All right. And you see Mr. Luttrell here? Do you see Mr. Luttrell? Counsel?
I believe so. Can you raise your hand? Yeah, okay. Yes, I do.
All right.
Dr. Ballard, can you hear me?
Yes, I can.
Okay.
You may proceed.
All right, Dr. Ballard, if you could please raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide the court in this matter is the truth and the whole truth, you so swear or affirm?
I do.
All right. Dr. Okay. All right. Dr. Ballard, could you please state your educational background?
Yes, I have a Bachelor's of Science in Biological Sciences from Sacramento State, and then I have a master's degree in genetics with an emphasis in human genetics from UC Davis, and also a PhD in genetics with an emphasis in human genetics from UC Davis.
Thank you. And what kind of work do you do, Dr. Ballard?
Well, currently, I'm working full-time as a forensic DNA consultant, but my primary career from about 1996 to 2024 was as a professor at California State University, Sacramento, where I taught the program in forensic biology and DNA, and I developed and taught it and did research in that discipline.
Okay. What were the duties of your job as a professor when you were a professor, doctor?
Well, there were 4 general duties. One was teaching, and that was primary at that particular university. So I did a lot of curriculum development and working with students in the classroom. And the primary thrust of what I was doing was to train students that wanted to become crime lab workers when they graduated from college. So the second part of that, an important part, was research. So I ran a research lab both there, and actually I ran one for 5 years at UC Davis as well in their forensic biology or forensic science graduate program. And we studied various questions in forensic serology and DNA in the laboratory using the same technologies and approaches that are used at modern crime labs. We also got, professors are required to be involved in committees and university governance, and then I also did community service as well as part of my job.
What are your duties in your role as a forensic serology and DNA consultant?
So primarily what I do is that I do case reviews. And what those consist of is I get contacted by an attorney, usually a defense attorney. Those are the ones that contact me. And they say, you know, I've just been given some legal discovery around DNA evidence in my case, and I don't have a background in that, and I need an expert to look at it and tell me what the strengths and weaknesses of the prosecution's case are in terms of the DNA. Make sure the work was done correctly, that you don't have any issues with that, and then help me understand and interpret how this plays out, you know, in the particular, given the particular context of the case. So that's essentially what I do. That usually includes a review of any crime lab reports, the analyst bench notes associated with those reports, electronic DNA data files associated with those reports, and then these days especially I look closely at probabilistic genotyping. Statistics is usually what people are using, so I'm looking at those reports and so forth. And then once I have gone through all of that, I then usually meet with the attorney and discuss my findings. And then beyond that, I will also look at the context of the case. So what are the charges against the client, read the police reports, look at sexual assault examinations if it's a sexual assault case, or autopsy or things like that if they're relevant. So all of that I look at, and anything else, sometimes there's body cam video that I look at, so anything else that's pertinent to understanding the DNA in context.
What's the difference between forensic serology and forensic DNA?
Well, forensic serology is a lot older to begin with, and that is the detection of body fluids. And so these are tests that look for the presence of, for example, is this red stain likely to be blood? Is this clear stain saliva? Could it be semen? And then looking under the microscope, looking for spermatozoa. Those are typically the tests that we do. And the reason we do it is you could imagine if you had, say, a bed sheet and it had some stains on it, maybe they're clear in color, and you really don't know where to go to find stains that would likely have DNA from either the victim or the perpetrator or both. And so we use these screening tools to locate these stains, body fluid stains, and then the cells and the DNA that they contain, ultimately to get DNA profiles from that evidence. So it's largely a way of finding evidence, but it also tells you something about how the evidence got there. So obviously, if you have spermatozoa and you get a single source male DNA profile from that sample, then you know that the source of that, the bodily source of that DNA was sperm. So it tells us something about also the transfer that happened.
Okay. Are there different software programs or tests which can be used for forensic DNA analysis?
Yeah, I mean, there's, so basically a forensic DNA analysis usually starts with the DNA extraction after the serology is completed. And this involves taking whatever substrate you have, which might be a swab or it might be a cutting, say, from a piece of clothing, and soaking it in some buffer and a little bit of detergent and an enzyme called proteinase K, and that helps the cells come off of the substrate if there are any cells there, and then pop open and release their contents. After that, there's DNA extraction or purification, which purifies the DNA out of all the other cell contents, like proteins and lipids and other molecules that we don't want in our preparation. And that's typically done on robots these days, so there are robotic instruments that do that with various chemistries involved in that. A very popular one is the Easy Run. And it uses a sort of what we call silica bead preparation to do its purification. But anyway, there's different techniques. There's a variety of them out there on the market. Once we have a purified DNA extract, the next step is to figure out how much human DNA we have, if any, and if any of that human DNA is male in origin. So try to get a sense of whether or not we have a mixture of female and male DNA, whether it looks like it might be all male DNA or whether it's all female. And that's really important, especially in sexual assault cases, because if you're screening sexual assault evidence and you don't find any male DNA, and the allegation is a female victim with a male perpetrator, you're probably not going to take that sample forward for analysis. So it's a very important step. It also informs us about how to set up our DNA profiling downstream, how to set up that reaction. So there's a lot of information. It also tells us information about whether or not the sample is degraded. So there's a lot of good information in that quantitation step. And that's done by a procedure called qPCR. And that uses real-time qPCR instruments. And it uses one of many types of chemistries that are available on the market to do that. And then finally, there's also DNA profiling. That's where we actually amplify short regions of DNA that are different in different people in the population. Those are called short tandem repeats. And we amplify those. We create millions of copies of them. And we do that on an instrument called a PCR instrument or thermocycler for the amplification. And then we move that over to a capillary electrophoresis instrument, which separates and detects the fragments and produces a DNA profile. And then we use computer software. GMAP or IDX is the most common one for analyzing the DNA profiles and making our interpretations. And then once that's completed, we may or may not use one of these probabilistic genotyping programs that allows us to do a more sophisticated deconvolution and analysis, especially if we get a complex low-level mixture of DNA. So all of those are used. There's also a bunch of kits on the market for doing DNA profiling. There's options out there for different labs, and different labs use different ones, but they're all operating on sort of the same technology.
Okay. What is your understanding of the TrueAllele software, so the TrueAllele program? So
TrueAllele is a probabilistic genotyping program. And just to give just a little bit of background, when our chemistries and instruments started getting really sensitive, what we realized was that if we went and started swatting doorknobs and steering wheels and items like that, that people had merely touched, that we would oftentimes get very low amount of DNA, but we would be able to detect it, and complex mixtures, so mixtures of 3 or 4 different people. And at the time that we started to begin to detect it, we didn't have these probabilistic genotyping tools to assist us as analysts in our interpretation. And so it was really difficult. We had to do what are called manual interpretations, and different laboratories around the country were doing them differently and coming up with actually different answers to the same profiles, which we found out when NIST started sending around a whole bunch of profiles to different labs and asked if they could get the right answer. So we knew there were some issues with our manual interpretations, that we needed some help with it. And some of these big data companies got involved, and they used biological modeling, sophisticated biological modeling of how these profiles behave, and then also computer algorithms to deconvolute complex DNA mixtures into their component parts, and then compare persons of interest, victims, suspects, whoever, against those deconvoluted profiles to see whether people were included or excluded, and with what statistical weights or confidence we could say that. And so these tools have really been a big change to our profession. Most labs had them on board around 2020. Some labs are still adopting them, but one program that's out there is called StarMix. That's the most popular around the country. It's used more often than other programs, but TrueAllele is also well regarded, and it's used by, I don't know how many labs in the country now. Not as many as StarMix, but it's used around the country as well.
How long has TrueAllele been in existence?
I think it's been around quite a while, in sort of beta format. So, I think some of the papers started coming out maybe as early as 2000 from Mark Perlin and others, he's a major developer of it. But in terms of adopting it, most labs weren't adopting those kinds of probabilistic genotyping programs until around 2015, 2016, something like that. Okay.
Now, the companies that design the DNA software for comparison, did they provide training for, open training for experts such as yourself to review how they collect and analyze the data?
Well, so StarMix does. StarMix has 2 trainings. They have an introductory training, which is a week-long training, and they also have a virtual advanced training, and I've taken both of those. And as an independent DNA expert, I was permitted to sit in on those and participate as a full participant. And I was able to purchase the software, and I was able to use it in my own laboratory at Sacramento State, and then I also use it in my work as an expert. TrueAllele is a little bit different. Cybergenetics, and I'm not saying there's anything wrong with the company. I'm not saying anything bad about them, but they don't have an open training for analysts like myself. Now, that being said, they've been helpful to me when I've had questions. It's just that when I asked if I could purchase the software and if I could become fully trained, they're not doing that yet for independent experts, at least at the time that I inquired about it, which was fairly recently, within the last year. So, so I'm not, I admit today, I do not consider myself to be a top expert on TrueAllele. I have done a research study with a student at UC Davis and a colleague named Dr. Ruth Dickover, who used to run the Kern County Crime Lab. She was the DNA technical lead there, and they use True Allele. So I learned a lot about True Allele from her, and during the course of that project where we compared the performance of True Allele and StarMix. But I have not taken any formal training from cybergenetics for True Allele. And when I have a case that involves True Allele, I usually contact them and get advice on reading the reports and things like that, just to make sure I'm getting it right. I do consider myself to be a good expert on StarMix, which is the other probabilistic genotyping program, and they operate under similar guidelines, but there are a number of substantial differences as well.
All right. And have you testified as an expert in forensic serology and DNA?
Yes.
Okay. And how many times have you testified as an expert?
I think as of today, about 53 or 54.
Okay. And in those cases, and have some of those cases involved True Allele?
Yes, they have.
Okay. And let me ask you, do you only testify for the defense? Do you ever testify for the state?
Rarely. I have testified for the state, but and I'll say also, when we're talking about criminal matters for the state versus the defense, it's the defense attorneys that contact me because the prosecutors use the criminals at the crime labs as their experts. So that's the reason. It's just sort of the way it's set up, the system's set up. When I'm doing civil litigation, I'm about equally between plaintiff and defendant in terms of who contacts me. But in criminal cases, it's almost always the defense.
Okay. And what jurisdictions have you testified in?
Oh, my goodness. Well, I've testified in, I think, 25 counties in California. I've testified in Arizona. I've testified in Nevada, Washington State several times. I've been to Illinois, Wisconsin, Georgia. That's something I'm thinking about. But yeah, Idaho. The recent was in Idaho. So, yeah, all over the place.
All right. Your Honor, at this time, we would move to admit Dr. Ballard as an expert in forensic serology and forensic DNA.
Any objection, Ms. Ross?
I guess, Your Honor, at this time, I need to, I guess, ask defense counsel, is she going to be offering any opinions on True Allele or just forensic DNA in general?
Her primarily is going to be testifying as to forensic DNA in general, but she may have some comments about the True Allele.
Okay. If I may just voir dire a little bit, then, Your Honor, and then the best way to do this probably is for me to make a contemporaneous objection if I believe she has strayed outside of her expertise, which I will do. Just for background for the record, because none of this is on the record, at 4:15 p.m. last night, I got her expert report, which is 6 pages long. Had we not been in this posture, I would have, one, reached out to the doctor and, hello, Dr. Ballard, we've never met. Hope you're feeling better, which was not able to happen under the circumstances that I was put in. And also, I may have, after speaking with her, potentially filed a Daubert on this issue. Because we are not before a jury, and Your Honor would be hearing the Daubert anyway, and Your Honor will be the fact finder, I'm putting this on the record to let you know I'm not waiving any Daubert issues. I may actually supplement the record after this testimony in regards to the reliability, repeatability, Daubert factors. But I need to explore some things that I normally would have done in a Daubert hearing that we were just unable to do so because of the timing. So with that, if I may just voir dire a little bit, and then I'll probably just make an extemporaneous objection if I believe she's strayed outside the expertise. Right. Thank you. Do I need to stand or sit? What's the best way to do this? It's kind of hard to stand and talk to the microphone. May I be seated? I may be seated? You may. Thank you. Good afternoon, Dr. Ballard.
Hello.
I just have a few quick questions for you about your training and experience. It seems to me, based on your CV, your predominant career has been in academia. Is that correct?
That's correct.
Okay. And from about 1996, I didn't really memorize it, but like 24, you worked for basically the University of California system. Is that right?
Well, I worked for the California State University system as my primary job, but I also worked, as I said, as the forensic DNA and biology consultant for the forensic science graduate program at the UC Davis system. So that's University of California. Those are two different systems, but I've worked in both.
And when you talk about, well, let me just ask you this. Have you ever worked in a forensic crime lab?
Not as an employee. I did in a sabbatical there, and I visit crime labs frequently, but I've never been employed by a crime lab. That hasn't been my career.
Have you been a forensic serologist where it is your job to process items of evidence for biological materials?
Well, what I do is I do all of those things within the context of research. So we would collect and we would process in the same way, screen, do all the DNA typing and all of that using the same approaches and tools and chemistries and technologies that are used in modern crime labs. We're just using it for a different purpose.
Okay. Do you testify to those results in a court of law, the things that you do for research?
Sometimes, yes.
And when you're doing your things for research, the place that you're doing it, are they QAS or ASCLD accredited laboratories?
Well, that's not an appropriate thing for a research laboratory. So we're not issuing reports on crime scene evidence and things like that. So we're accredited through the university's accreditation process.
And could you explain for me then a little more why that wouldn't, well, first of all, what is QAS for the record?
Well, it's quality assurance, and the idea is that anytime you have a product going out the door, like a report, for example, or a product that you make in a company, it goes through some type of a QC process as it goes out the door, and you establish various techniques and protocols within the laboratory to assure that most of those, hopefully, are going to pass muster as they go out the door. In other words, you have training in place for your employees and all these kinds of things to assure that, that everything that you produce and it's being purchased, et cetera, or in this case, in the case of a crime lab, a report that goes out is accurate. We don't do that in academics. It's just not how we do things. We don't do ASCLD accreditation. There's no requirement for it, and there's no, people just don't do that in research. That's not the way we do things.
Okay. You would agree with me. Are you familiar with the Georgia Bureau of Investigation?
Well, I reviewed things a couple of times for them, yes.
Okay. And they are a QAS accredited laboratory by the FBI? They comply with QAS?
I believe so. I don't remember looking at their accreditation certificate when I looked through here, so I'm guessing that that's probably true.
Okay. Outside an academic setting, you have not worked then in a forensic laboratory that is required to be accredited by either ASCLD or QAS, FBI, and produce reports?
Yeah, only when I was doing my sabbatical in the crime lab.
And when did you do your sabbatical, and in what crime lab did you do your sabbatical?
I did it in the Sacramento County DA crime lab, and I don't remember the year. I'm thinking it was probably around 2006 or 7, something like that.
And you were there for the year?
I was there for 6 months.
6 months, okay.
Yes.
All right. How many times have you amplified DNA?
Thousands.
Okay. And all of those thousands of times have been in the academic setting?
Yes. I have done it in crime lab setting, but like you said, that's not been the primary focus at all. It's been academics.
Same question I have for you for quantification and amplifying. Have you ever done that? Go ahead.
Yes. So DNA quantification is qPCR, and I've done that thousands of times also.
In an academic setting or in a forensic lab?
Both, but primarily academic.
Okay. Have you ever testified in a court of law to DNA results that you obtained yourself? I mean, you did the extraction.
Yes, I have. Yes, I have.
And approximately
yes.
How many times?
I don't know. I would have to look back at my CV and my cases. It's unusual. I mean, it's not the normal thing. Usually I'm doing a case review that's work done by another laboratory. I mean, by a laboratory, a crime lab, like I did in this case. But there are times when I will do an experiment in my laboratory that is pertaining to a particular case that there isn't a good body of research literature about that topic. And so in order to investigate it, I'll do the work in my lab and then I testify to that in court.
You testify to your experiment?
Yes.
Okay. And you don't know, sitting here today, how many times you've done that?
No.
All right, have you ever ran, I think I know the answer to this when you start talking about true allele. Have you ever operated the true allele probabilistic genotyping software?
I have been involved in it because like I said, I did a research project where we compared star mix and true allele. So I've been involved in that. Like I said, I do not consider myself to be an expert in true allele in the same way that I am with star mix. And I usually get some outside assistance when I have a true allele case for that reason.
Okay. So you would not consider yourself an expert in true allele?
I'm an expert, I would say I'm an expert in how probabilistic genotyping works, what it is, and I understand the differences between true allele and star mix. I'm not completely ignorant. But because I haven't run thousands of samples through true allele the way I have star mix, I don't feel as confident on it. And so, yes, I would say that I don't consider myself to be an expert in that particular probabilistic genotyping software.
Well, that's what I'm trying to get to the bottom of. How many times have you ran true allele?
Well, in our research project, we ran it hundreds of times. I think I can't remember the sample size. It was probably 300 samples, something like that, where we ran star mix and we ran true allele. So it's not that I haven't seen it and done it, and it's not that I haven't read about it, and it's not that I don't understand how it works. I think I have actually a better understanding of true allele than most experts in the country that are coming to court, because most of us are experts in star mix. True allele is not used by very many laboratories, and so to be experts in both would be a very unusual thing.
Okay. So 300 times, were you running the program or your graduate students?
I was running it with them.
Okay. So together?
Yeah.
Right. And you know Jennifer Bracamontes from Cybergenetics?
Sounds familiar, yes.
Okay. Is she possibly one of the persons that you might talk to at Cybergenetics if you have a question about true allele?
Usually I talk to Bill Allen.
Okay. And you know Dr. Perlin as well? Mark Perlin?
I don't know Mark personally, no.
All right. Your Honor, that'll complete my voir dire as for her expertise. I'm not going to object to just serology and DNA, and if she strays outside of that in a manner that I find problematic, I'll lodge a contemporaneous objection.
And for the record, we're asking that she be qualified as expert in forensic serology and forensic DNA.
I'll allow the witness to testify as an expert in the area of forensic serology and forensic DNA.
All right. So when you get involved in a case review, how does that process normally start?
Well, typically I get contacted either by email or phone by the attorney who needs my help. And so if I'm available, they'll first ask me if I'm available, if I have time to take the case. And if I do, I'll say yes. And then we usually talk about it either in a Zoom meeting or over the phone to discuss sort of, what the case is about. So I make sure that it's a good fit for my particular skill set. And then once we've established that it sounds like it is, then we talk about, okay, where are you in the process? Do you have a trial coming? Do you have a hearing coming? What's going on with that? So we begin the conversation about retaining me and how we're going to share the discovery and things like that.
Okay. And so where do you get the materials for case review?
I typically get them from the defense attorney that I'm consulting with, who gets them from the DA, who gets them from the crime lab. So in terms of the DNA discovery, that's usually how it comes to me.
Okay. And you're not collecting the samples yourself when you're doing these case reviews. You're getting the material from the defense attorney. Do you ever get them directly from the state?
Not usually. I have sometimes gotten them directly from the crime lab, but it's always with the permission of the DA to release them to me. Sometimes when the files copy over, they don't copy over right, and so it's just more expedient to have the crime lab actually send them directly to me.
All right. And generally, you're involved post-arrest. Is that correct?
That is correct.
All right. And are you compensated for your time?
Yes, I am.
All right. And how are you compensated?
Well, I charge $300 an hour for a case review, and typically I can finish a review in about 15 hours. So that's about $4,500 for the pretrial work. If I end up traveling for testimony, I require a $1,200 flat fee for court testimony, but when I come on Zoom, I just charge by the hour at that same rate.
All right. And is this standard in the community of expert witnesses who testify in this area of forensic DNA? Is this a standard practice?
To charge?
Yes. Charge fee.
Yes. Yes. And I also work a lot for public defenders' offices who have tight budgets. So I'm within their budget for experts in terms of my $300 an hour.
Okay. Do you always testify in cases?
No, I don't. So if you look at my CV, I think I've done about 350-something case reviews at this point, and I've testified in a little over 50. That's about, 1 in 6 or so. So it's, it's less than 20%, I would say, at this point, that I testify in.
Okay. And you charge for your time, not for specifics of your testimony. Would that be fair to say? Or correct?
Yes. So, yes, so my job is to look at the crime lab work with an independent set of eyes and to give an honest opinion to the attorney. The attorney then makes a decision, a legal decision, whether to bring me in or not as an expert and to testify. So that's out of my hands. I'm just there to give an independent, honest opinion.
And just so we're all clear, you were hired in this case by Georgia Public Defender Standard Counsel, correct?
Correct.
All right. Now, I'm going to talk a little bit generally about DNA. What role does DNA play in criminal cases?
Well, it kind of harks back to a major concept or founding concept in our discipline, which is called Locard's principle. And this is the idea that every contact leaves a trace. So if you think about a hit and run accident, somebody gets hit by a car on the road and the car speeds off, you might find, windshield glass embedded in the T-shirt of the victim that's lying on the road. That's a transfer from the car to the victim. And if you were able to find the car later, you might find blood from the victim on the windshield of that car. Okay? So that is the idea that when two things come into contact, there'll be some type of exchange. And the idea behind Locard is that holds out in forensic investigations. And so it's a very old concept. It's been around a long time. In terms of DNA, it's just extending that concept to understand that DNA can also be transferred. It can be transferred in a crime or even innocuous situations like a household or whatever, but it can be transferred between people. It can be cells in their DNA can be transferred between people. It can be transferred from, say, a victim to a crime scene. Maybe they bleed on the carpet. It can be transferred from a perpetrator to a crime scene. Maybe they get cut as they're knifing a victim, and when they leave, they're dripping off blood, a blood trail away from the scene. It can be left on a weapon, the victim's blood on a weapon, or say touch DNA from the perpetrator on the handle of that weapon, and so forth. So it can be transferred in ways that can help us, assist us in understanding what might have happened and who might have been involved.
Can I stop you for a moment, please, Dr. Ballard? Keeping in mind that this is not a jury, and that while I'm certainly not an expert, I've heard of this many times. Perhaps we could narrow this, not only the questions, but also the responses. If you would just be responsive to the question, and if he needs to follow up, Dr. Ballard, he will, because of the purpose of this particular hearing. We're not in a trial. This is a motion hearing. So, thank you.
All right, Your Honor.
All right.
Before we proceed, could we take a few minutes, just so I can use the restroom?
If you need to, but I'm not dispersing everybody. If you need to step away for a minute, I'll allow you to do that. And are you asking that we stop while you do that?
Yes.
Then we will.
Thank you, Your Honor.
That would be, come on around, let's do that. So, that's fine. So, and I don't know that one. Okay, but you can't do what you just did from now. I cannot do that. Okay. Thank you. I proceed.
Thank you, Judge. Before I go on to more, I did want to touch on one thing. I wanted to ask you about concept transfer of DNA, direct and indirect. Can you tell us a little bit about that concept of transfer of DNA, direct contact, direct and indirect transfers?
Sure. I'll give you an example of body fluids, and I'll do one with touch DNA or skin DNA. So let's say that I bleed onto a Band-Aid. That's direct transfer of my blood onto that Band-Aid. Say I take the Band-Aid off and I put it on a counter, and my husband comes by, picks up the Band-Aid, and gets some of my blood on his fingers. That's indirect transfer. So the blood is now on his fingers, even though he never touched my wound directly. The Band-Aid was the vector for the transfer of that blood and its DNA. Similar things happen, if I touch a microwave handle and open and close it, and then somebody else comes into the room and does the same thing, they could pick up some of my skin DNA on their hands without having touched me directly. So again, in that case, the microwave handle would be the vector for indirect transfer. So when I touch the microwave handle and leave my skin cells and DNA behind, that's direct. And then if somebody comes in and touches the microwave handle and then picks up my DNA as a result of that, after I've handled that handle, that would be indirect.
Okay. So if I want to make sure I get this right so I understand. So I'm holding a pen in my hand. I don't know if you could see me with the pen. If you pick up my pen, you could leave your DNA on the pen?
Yes.
Okay. And so, and if I touch the same item, then my DNA would be on there as well, correct?
Correct. It could be.
And then if I've been handling this pen all day and I went home and I opened the door to my house, could your DNA be on the doorknob as I opened the door?
It could be.
Okay. Even if you've not been to my house, you've never been there, your DNA could still be on that doorknob.
That's correct.
And have you done research in this area, the transfer?
Yeah, about the last, I would say, 10 years at Sacramento State, most of my research was focused on DNA transfer, particularly of skin DNA. So 2 recent studies, or I mean, if you want an example of studies, I can give you a couple of recent studies that I've done. I want to be responsive to your question.
Okay,
so.
yes. What recent studies have you done, just so we're briefly?
Okay, well, one study we did was of cell phones. So we collected 55 cell phones from volunteers. They had to fill out a questionnaire specifying that they don't share their cell phone with other people. So they're the primary user, only user of the phone, and that they don't wash their phone. That was the things we had to screen them for. And then they gave us their phones, and we swabbed those phones. Then we collected reference DNA samples from them, so we knew what their DNA profiles were. And then we went back to the lab and ran the DNA profiles off of the swabs we took from the cell phones and ran the reference samples for the people who owned the phones. And so what we were interested in is we wanted to know whether or not there would be mixtures of DNA from more than one person on a person's cell phone. We also wanted to get a sense of how much DNA was present. Human DNA was typically present on cell phones. What was the average amount on those 55 phones? And we also wanted to know whether or not the person who owned the phone was always the major contributor, if it was a mixture, or if they were sometimes in the minor slot, one of the minor slots. In other words, they contributed less DNA to the phone than someone else who doesn't even own the phone. And so the answers to those questions were, on average, in our study, it was about 2.5 people of DNA, 2.5 people contributing DNA onto cell phones. So we definitely had mixtures. We did have some single source, but we also had some very complex mixtures, up to 5 people in a mixture. We also found that the primary user of the phone was typically the primary contributor in those mixtures, but we did see a couple of cases where they actually were a secondary contributor. And so we also got a sense of the amount of DNA, and it's actually quite remarkable that we accumulate quite a bit of DNA onto cell phones. We had cell phones that had 10 nanograms of DNA on them, for example, which is a lot of DNA when we're talking about something that has been handled. Now, we also talk into our phones, so we're spitting spittle on them too, and that has more DNA than skin cells. So, but anyway, that was one study that we did. And another study we did was on cats and dogs. So we were interested in whether people shed their skin DNA onto their animals, their domestic pets. And so we went in and swabbed domestic pets, and we also swabbed their owners to see whether the owner's DNA was present on the pets. We also wanted to know whether there was DNA from unknown people.
Suggestion or direction was taken.
Okay.
Do you want me to control it, or are you going to?
I'll move on to the next question, Judge. If that, I get. Let me just. Can DNA tell us when something when does DNA analysis tell you when DNA gets on an item?
It can.
Okay. How can you determine that?
All right, I'll give you an example, specific example. So let's say that you have seminal fluid with sperm in it inside of a female, inside of her vaginal cavity. We know that spermatozoa don't survive inside the vagina cavity for more than about 7 days, and usually they're gone by maybe 3 or 4 days. So if you find sperm inside a vagina cavity, then you know that it was deposited within about the last week. That's why with sexual assault exams, we want victims to come in quickly. So there are conditions in forensics where we can actually say something about the timing. But if we're talking about an inanimate surface, like, for example, I swab a piece of clothing and I find DNA, then it's very difficult to know. I mean, there really isn't any way of knowing exactly how long that DNA has been there. We don't have a good way of doing that yet. So it could have been deposited there months, weeks, days, even in some cases decades. I've seen contact DNA or touch DNA actually recovered from items even decades after they've been touched. So we don't know in those types of items.
Okay, let me ask you, can you tell how it got on, when you're talking about contact DNA, touch DNA, can you tell us, can DNA analysis tell us this, can it tell us how it got on that item?
It can tell you, so I do consider the amount of DNA we're talking about. I like to do DNA yield calculations in all of my case reviews because I want to see whether we're talking about a few cells worth of DNA, which, could get there almost in so many different pathways, both indirect and direct, or whether we're talking about hundreds or thousands of cells worth of DNA, in which case, if I got that, say, from the collar of a shirt, I would be very unlikely, I would think it very unlikely to be indirect transfer of that DNA. So even with contact DNA, if we're sort of talking about amounts, and we're talking about extremely large amounts versus extremely small amounts, you still can say something about, how it might have gotten there.
All right. I want to talk about going back in time from about October of 2024. Were you contacted by Mr. Ibarra's trial defense team?
Yes, I was.
Okay. And do you know, how did they contact you?
As I recall, they contacted me by email and wanted to know whether I was available to work on this case.
Okay. And when you have dialogue with attorneys, and would you have told the trial team what you would need, what you would need to in order to complete your review of the evidence?
Yes, I usually send them a complete list of DNA discovery to request from the DA because most attorneys don't know what to ask for. And then I'll also give them a time frame for my review.
All right. And so what is your time frame for review?
Typically, from the time I receive the full discovery to issuing a report is about 6 weeks.
Okay. Now, back in October 2024, did you have other cases that you were working on at that time?
Yes, many.
Okay. Can you give us a couple, a couple cases that we might have heard of?
Well, I was working on the University of Idaho student murder case at that time. I can tell you that. That was taking up quite a bit of my time. But there were numerous other cases that I was working on that very week when Mr. Donnelly contacted me.
Okay. At that time, did Mr. Donnelly talk to you about specifics about what scheduling order for the trial and motions? Did he talk to you about that?
I don't remember specifically. I know that he asked me about my time frame, and I explained that to him. I have email correspondence on that. I don't recall if he actually said, any particular dates to me and asked me if I could be ready by that date. I don't remember that.
Okay. So you weren't aware that there was a motions hearing held on November 1st, 2024 on the issue of, the challenging the true allele and on the DNA?
No, if I had known that, I would have told him there's no way that I can, I don't even have the discovery yet, much less have time to do a review in that period of time. Yeah.
And given that you wouldn't been, so you would not have been ready for the November 1st motions hearing. If you were even if retained, you had not been able to complete your review within a week. Fair to say?
No, that is fair to say.
And I believe this trial started November 15th, about 2 weeks later. Time period of November 15th through 18th. Would you have been able and ready to, with that, given the cases that you had at that time, would you have been able to do a full review?
It would have been very difficult for me to do that, and I didn't even have the discovery at that point. So the 6 week time frame is coming from the day that I get full discovery. And part of what I do immediately when I get discovery is to go through it and see what's missing. And once I realize what's missing, there can be additional time required for me to get what I'm missing, and then to get the lab to respond to that and give it to me. And so the clock keeps moving. So the answer is that unless every star aligned, and all of that came to me, and I was able to push everything aside, I would not have been able to do it now.
And you were like the Idaho student killing, you were already retained on that case. So you already had deadlines and work that you were having to do on that case.
Yes, and many other cases too.
Many other cases.
Yes.
All right.
Yes.
All right, Your Honor, if I may move to the podium to introduce them.
Right. And while you're doing that, I'm going to take care of another quick matter. Come on. While you're getting set up.
I just didn't know how you would explain it. He'll hit the judge. I'll switch. I was 2 and 3.
Okay.
Yeah, do yours too.
All right, hold on.
No, because mine might.
Okay, that's fine. We'll do that.
Because mine also is really defense persons.
All right, you may proceed.
All right, Dr. Ballard, I want to make sure. Can you see what I've got on the Elmo?
I can see that you have something on the Elmo. I can't read any of it.
Okay. All right. I don't know how we can. Can you change your view setting from where you are, Dr. Ballard?
Let me see what I can do here. I can get the layout, do a full screen, see if that does it.
If you do stack view, if you do stack view, you should be able to see it.
Okay, I'll try stack view. Yeah, that on stack view. It's a little better. Good afternoon, Dr. Ballard. I can see I have gotten access to the data. Okay, I can read it now.
Okay. I'm going to show you what's marked as Defense Exhibit 1. Do you recognize this email addressed to yourself?
The state would have no objection to the admission of offense exhibit 1.
All right. Once admitted.
One's admitted. All right, with that, I'm going to show you what's marked as Defense Exhibit 2. From that email, were you able to go to access the information? Well, let me ask you, do you recognize this screenshot?
Yeah, it looks like it's the links to the various folders from the crime lab.
No objection to defense 2.
Two's admitted.
You? show you D3, the record certification. Did you pull this?
Yes, that was part of that.
No objection to D3.
3 is admitted.
All right. Now, I'm holding, there's a USB that can, and did you download, there was 3 zip drives. Did you download those drives?
Yes.
Okay. Your Honor, at this time, I've had some discussions with the state as far as D4, 5, and 6. These are the zip drives which we have downloaded that was accessed from the State Defense Exhibit 2, downloaded. We've given it to the state for them to review. We'd ask that that be admitted at this time.
Just D4?
D4, 5, and 6.
What's 5 and 6?
Each one, D4 is zip file 1, 5 is zip file 2.
Oh, are they all on the same thumb drive?
They're all on the same thumb drive.
Can we just have D4 for the?
We can do that.
It's one thumb drive, so it'd be very confusing if it has 3 different numbers.
We can, D4, we would ask that you do D4, Judge.
And Judge, I have no objection to the admission of D4 with this caveat. So this is the conundrum we find ourselves in with virtual witnesses, which is why I rarely waive my right to cross them in person, but I'm doing it in this case, and I did willingly once I got the report. Usually we would have the witness authenticate it, and we can go through it that way, but she can't do it where she's at. So I've made an agreement with the defense attorneys that I will agree that D4 is what they gave their witness from the GBI. I can't verify whether it's exactly what I have, and we don't have time for that, but I am happy to stipulate that D4, based on defense attorney's recommendation, or not recommendation, but their assertion, that D4 is the data that this witness was able to access from the GBI server, and it was downloaded onto a thumb drive, which is D4.
And I'll state my place, that's what happened.
And I can't tell if she downloaded it all. I don't know. I wasn't there. She can't see it, but I'm okay with that stipulation.
I will admit D4 with the reservation stated by the state.
Thank you. And based on the review, did you review those files?
Yes, I did.
All right. Just a couple of other things. Did you prepare a report in this case?
Yes.
I'm going to show you, and this is now marked D5.
No objection to the report, D5.
5 is admitted.
And this will be, actually, this will now be Exhibit D6. Did you create a spreadsheet?
Yes, I did.
Okay.
No objection to D6.
6 is admitted.
Thank you, Judge. With that, if I may, you want me to present this to your court reporter?
That'd be fine.
Thank you, Judge. Let me just do that, and I can go back to the table. That completes our portion of evidence that we are admitting. Dr. Ballard, do you have the ability to screen share where you are? Can you screen share? Because I think you have the spreadsheet with you.
I don't think she can hear you from where you're located.
Sorry, Dr. Ballard. I think I was just talking while I was walking through the courtroom. Do you have the ability to screen share where you are? Can you share?
I should be able to if you give me permission.
Judge, we would ask for permission to screen share.
She may.
Okay, let me see if I can pull up the spreadsheet here. I want to make sure I get the right one. See if that's the right one. No, that's the wrong one, so sorry. I've got to pull up the right file, so if I could just give me a second here.
And while she's doing that, Judge, we can we've already prepared, we've given a copy to the state. If Your Honor, we could give you a courtesy copy as well.
Thank you. That in mind, if I've got this, you've got yours, she's got hers in front of her, I don't know that do we need to screen share?
Well, Your Honor,
I think I can read mine to mine. The problem is that I can't figure out how to get out of the screen to open up what I need on my desktop to make sure I can access it. This is a program I'm not used to using, so layout. It doesn't help any.
Dr. Ballard, when you're testifying about the spreadsheet, could you just note for us, for the record, which row and column you're referencing, and then we can follow?
Sure, I can do that, yeah.
All right.
And if they're doing that, Judge, I would just like to make sure that the record is clear, number one, that Mr. Ibarra can see and hear the witness based on where he's seated in the courtroom, and that he is able to follow along with defense counsel with that exhibit.
Can you confirm that with your client? Ms. Smith will come over.
Yeah, I can. All right. So just tell me a little bit. Let's start first. Talk about how you set up your spreadsheet, Dr. Ballard.
Okay, well, the spreadsheet's designed to give me an overview of everything that was tested in the case, what tests were performed, and what the crime lab results were. So it starts on the left-hand side with the first column, which is the lab item number that was assigned to the evidence when it arrived at the crime lab. And then the next column is the description of that item. And this is all taken from the analyst's bench notes. And then if there were any sub-items and what their descriptions were and so forth. And then if they did any body fluid identification, serology, I indicate what tests they used and what the results were. And then this lab also did a little bit of male DNA screening on a few items, and so I have a column for that. And then I go into the regular sampling that they did for DNA. There's a bunch of blank spaces on the spreadsheet because I was unable to obtain the information I needed from the bench notes that were provided to me to fill that in. So I couldn't calculate how much DNA they found. I would normally do that in a case. And then after that is information about the profiles that they got, the DNA profiles they got, and the interpretation of those profiles in the report.
All right.
And then on the very far right-hand side is whether or not there was any DNA that could be reasonably assigned to any of the persons of interest in this case.
All right. So what was let's just start with the first item. What was the first item that you looked at?
So it was lab item 2, and it was a sealed package that contained disposable black gloves that was submitted to the lab for trace evidence, forensic biology, and latent prints. Of course, I only looked at the forensic biology part of this. So the first glove is assigned as 2A, the second one is 2B, the third one is 2C. Then they went into serology. So they actually did test these gloves for the presence of blood. And this laboratory uses 2 different tests for doing that as sort of backup, I guess, to make sure that the results they're getting are correct. This is what we call a screening test, so it doesn't say it's human blood. It doesn't say for sure it's blood, but it's a well-regarded set of screening tools for determining whether a stain might be blood.
Was there blood stains found?
Yeah, so there was blood found on all of the gloves. And those swabs were then, those stains were then swabbed. And there was also what they called contact swabbing of the gloves, of the glove, the first glove and the third glove. There was contact swabbing, which means that usually what that means, and the analyst would have to, explain how they use it in their lab, but usually what that means is that they're avoiding the stained areas and looking for skin cell DNA rather than looking for who's the source of the blood.
Okay. Then what was the next thing you looked at as far as the gloves?
Well, then we looked at the DNA. So they did not continue on with DNA typing with the second glove or the stain on the third glove, but they did do the stain that they found on the first glove and the contact swabbing from that glove, and they also did DNA typing on the contact swabbing from the third glove. And when they did that, they got complex DNA profiles. That means that there was a mixture of DNA, and they felt that the profiles were going to be better analyzed if they went into their True Allele software, and so that's what they did. And when they did that with the first stain, the stain on the first glove, that was a stain, remember, that tested positive for blood, they got a mixture of at least 2 contributors with a major and minor component, and they had a DNA match to the victim on the major component, and then the minor component was too limited in genetic information for them to do anything with True Allele. The contact swabbing was also 2 contributors with a major and minor component, and again came back to a match to the victim, and the minor component was too limited for comparisons. And then the contact swabbing on the third glove gave the same exact result. So all of the DNA that they obtained in the gloves came back to coming from almost with a very high degree of scientific certainty, coming back to the victim with a contribution, a very low contribution from at least one other person.
Was Mr. Ibarra's DNA found on the gloves?
No, that like I said, the major component came back to the victim, and the minor component was so limited that comparisons couldn't be made. So we have no idea who contributed that minor portion.
So that could be anybody.
Correct.
All right. What was the next item that you evaluated?
Should say it could be anybody but the victim, because it was somebody foreign to the victim.
All right.
Correct.
Fair enough. Actually, just to be clear, because that wasn't a very clear question I asked, and I'm going to clarify. It could be anybody as far as the minor contributor, the contributor of the minor profile. We can't determine who that person is.
Correct. It can't be the victim, though.
Okay.
Because there's 2 contributors to these profiles. So we know that the victim is the major contributor with a very high degree of scientific certainty. We just don't know who the minor contributor is, but it's not the victim.
Okay. What was the next item that you looked at?
The next item was the blue jacket, which was item 8. And on the blue jacket, they did test a stain. Looked like, I guess, like a blood stain on the jacket. And it was also positive in those 2 screening tests for blood. But they didn't take that one forward for DNA testing, so we don't know whose blood that is. They did do also contact swabbings of the jacket. So again, I'm assuming that this is areas of the jacket that were unstained. So trying to get information about possible skin DNA transfer, for example. And when they did that again, they got a complex profile, which is very common off clothing. The analyst decided that this was best analyzed by True Allele, not a manual interpretation that she could have done. And the result of that was at least 3 contributors to this profile. And there was a DNA match via True Allele to the defendant as well as to the victim. And the other people of interest that were tested here, Diego Ibarra, and I can't remember the name of the other Ibarra, begins with an A.
Arianes?
Arianes Ibarra. They were both excluded as contributors to the major component. So basically what this had was it had a major component that had 2 people in it, and then it had a minor component that they couldn't do anything with, they couldn't make any comparisons. But they were able to exclude both of those other 2 individuals as contributors to the major component. So this major component was a mixture of 2 people, including both the victim and the defendant.
Okay.
And I also did look at the DNA electrophoregram for this one and determined that the mixture ratio between the 2 of them was approximately equal, with slightly more DNA coming from the victim, and that was also borne out by the true allele analysis too. So I looked at the electrophoregram to make sure that it looked as if it was being interpreted properly by true allele, and it looked like it was.
All right. Does the minor profile, does it rule out Diego or Arianes?
No.
It does not.
No. It's, again, one of these ones that is too low in information for them to make any comparisons.
Okay.
So they're only ruled out as belonging, having contributed DNA to this major mixture.
Okay. So, and I'm keep mispronouncing his name, but Arianes and Diego cannot be ruled out. Is that correct?
That's correct. Nobody can.
Okay. And can you tell from, so we know that from your review, you see that DNA from Mr. Ibarra and Ms. Riley is present on the jacket. Does that result in and of itself, does that tell you when and how the DNA got there?
No.
Okay. And like for when could have the jacket for Mr. Ibarra, when could that have happened? Do you know? Can we tell?
Well, it's hard for me to tell for 2 reasons. I mean, one is fundamentally it's very difficult to say that. No, you can't say. I mean, he could have been wearing the jacket months, weeks, days, or at the time of the crime, before it was collected by the police. So in this particular case, it's we don't know when it got shed on there. The same thing for the victim's DNA. It could be possibly that when the analyst swabbed this, she was actually picking up some of the victim's blood without realizing it, like tiny spatters or something that she didn't see visually. So maybe that's the source of the blood.
At this point.
There's an objection, Dr. Ballard.
Objection, speculation.
Judge, she's testifying as an expert, giving her opinion based on what she reviewed.
Allow it. You may continue.
Okay. Or it could be she wore the jacket at some time. It could be that she grabbed the jacket. There's really no way of knowing how her DNA got there. No. I also don't know exactly where the jacket was swabbed. That wasn't clear in the analyst's bench notes. Whether she swabbed the entire jacket with a swab and kind of tried to pick up as much contact DNA as she could, or if she swabbed, say, the inside collar or something like that.
Is there any other findings that you, or opinions you have based on the findings as it pertains to the jacket?
No, I don't think so.
Okay. Let me ask you, for a hypothetical, does the finding of the DNA, does that exclude the possibility that maybe, if, for a hypothetical, that Mr. Ibarra may have just simply moved the body and not had anything further to do with it except for moving the body? Does it exclude that?
It doesn't exclude that if, I mean, he could have been wearing the jacket when he moved the body and gotten some of the victim's DNA on it during that process, or some blood, whatever. Yeah. I don't see that it excludes it, no.
Okay. And it also doesn't exclude that one of the minor profile one of the persons that contributed to a minor profile was wearing the jacket beforehand.
Correct.
They were wearing it when the jacket had contact with Miss Riley.
Correct.
All right. What was the next item that you reviewed?
The next item was item 14, which was a sealed sexual assault evidence kit from the victim. It contained some vaginal swabs, anal, perianal swabs, and oral cavity swabs. And what they did was the analyst screened those for male DNA to see if there was any male DNA present and did not find any. And so there was no further testing of those items.
Okay. So no male DNA found, correct?
Correct.
All right. We'll move on then to the next item. What was the next item that you reviewed?
Item 15, which was a sealed package containing a blood stain from the victim, which was taken in order to obtain her reference DNA profile for comparison purposes.
Okay. So is this like a control sample? Would that be fair to say?
Well, we wouldn't call it that. We call it a reference sample. But the idea is that, when we're making these comparisons with TrueAllele, we're asking TrueAllele, is this person a potential contributor? Is this person a potential contributor? And to do that, TrueAllele needs to know what the profile of that person is, right? So that's what that was taken for.
Okay. So I don't think we need to ask anything further on that. What was the next item that you reviewed?
The next item was item 18, which was a sealed package that contained the fingernail clippings, a collection kit taken from the victim. And there were two sub-items there. There was fingernail clippings from the right hand. There, in the bench notes, it appeared that the analyst noted there was some red-brown staining on those. And there were also some fingernail clippings from the left hand, which also appeared to have a little bit of red-brown staining of some kind. And those were assigned as 18A and 18B. 18A, the analyst took a wet and a dry swab, it's called the wet-dry technique or double swab technique. It's very common to collect evidence from the clippings. She assigned that as item 42. And then she also did the same procedure with the left-hand clippings, and she assigned that as item 43. So going forward into DNA, those were items 42 from the right hand and 43 from the left hand.
And what were your next? Based on that, what was your review on that? What was the next thing you reviewed?
Right. So the laboratory actually did two different types of DNA profiling on the sample. One of them is the normal DNA profiling that we do. This lab uses a kit called GlobalFiler, and it amplifies and types short tandem repeat markers from both males and females. And it's the one that has this very high level of discrimination when you get a good profile. There was also another kit called YFiler Plus that was used by the lab that looks at the same types of markers present only on the Y chromosome, which is found only in males. And so there were two different types of profiles to review and that are in my spreadsheet. When they did the Y-specific or male-specific testing, they got what appeared to be one male haplotype, which is what we call a profile off the Y chromosome. And what the lab was able to say was that it was consistent with the Y profile of the defendant and also the RNS, Ibarra. And just for context, in a family, the Y chromosome is passed intact from fathers to sons. So if two people are biological brothers, or if they are male biological cousins whose relatedness is through the paternal line, they're all going to have the same Y chromosome, and they're going to carry these same markers, so they're going to have the same haplotype. So anybody in that male line could be the contributor of the DNA, including these two particular individuals of interest in this case. So that's what the Y filer plus told us. They then went into the regular global filer test and produced a profile there. Again, due to its complexity, they decided to use TrueAllele as a tool to deconvolute the mixture. TrueAllele came back with at least two contributors, where the victim was actually assumed as a contributor in some of their calculations. So she was assumed to be present. And there was a DNA match also to the defendant. And then both of the other persons of interest were excluded as contributors. So what we learned is there are two people of interest in the case who were included by the Y filer testing, but when they went into global filer, the other one dropped out, and it's just the defendant here that's included as a potential contributor. I also looked at the DNA profile associated with this and calculated an approximate mixture ratio of 20:1, where the victim was the 20 and the 1 was, with a high level of scientific certainty, was the defendant. There was at least one male in the sample, but the male part was partial and very low level. I then confirmed that by looking at the TrueAllele mass table, and they had a ratio of about 95:5, which is 1:20. So all of that matched up, and I felt very confident that that was a good deconvolution of this mixture.
When you say it's a low contribution, what significance of that is that when you find that the mixture is 20:1 and the amount of DNA from Mr. Ibarra is likely very low? What's the significance of that?
Well, I think here, in this particular sample, when we're talking about DNA transfer, and again, I don't have all the numbers here because the bench notes were incomplete with regard to that, and so once I do those calculations, I'll have a much better idea of what's going on here. But if this turns out to be a few cells worth of DNA, for example, from the defendant, when there's very low DNA like that, the possible ways it might have gotten there are much greater than if there's a lot of DNA. Hundreds of thousands of cells worth of DNA, we're talking about a scratch. We're talking about somebody scratching somebody else and getting under their nails. Unless they shared a cigarette when they were smoking or something and they got saliva under there somehow, we're really talking about something that is probably drawn blood or there's some kind of body fluid involved. If it's only a few cells, you could get that by, carrying someone. You could get it by shaking their hand, potentially. So that, because it's so low, we're within the realm of being able to transfer it pretty easily through, non-criminal types of activities or whatever. So it does matter to me that it's, it's a very low, looks like it's probably a very low amount. I base that on the fact that it's only 5% out of the mixture, according to TrueAllele, and also according to my manual interpretation of the electropherogram. So I think that that's about right. And also the likelihood ratio here that included him, although it was 10 billion, and that sounds really high, in the world of DNA typing, that's actually a fairly low number these days if you have a lot of DNA. You get numbers up in the septillions and octillions and 1 millions when you have a lot of DNA in terms of inclusionary likelihood ratios. So from my perspective here, I'm thinking it's probably a fairly low amount of DNA from him, but I'll know more once I get the data that I need from the lab.
And just for the you were retained earlier this month, January 6th, correct? That's when you were formally retained on this? That
was when I was formally retained, and I believe I received the discovery on January 14th.
All right. Does the DNA results tell you, as far as the fingernail clippings, does the result tell you when and how the DNA got there? I know
No.
with Ms. Okay. We know Miss Riley, it's her DNA because it's her fingernails, but as far as,
Correct. In terms of her, I was thinking more about how the defendant's DNA got there, which is the matter of interest here. And I can't tell when or how it got there. Now, that being said, if I did get data from the lab that showed that it was hundreds to thousands of cells, which I don't think is the case given other things that are looked at on the sample, but if that was the case, then my opinion on that would be that it's more likely that that was some type of a scratch or direct contact type of situation, because, you know, getting that amount of DNA into your fingernails would be very unlikely just by, say, moving a body or touching somebody, you know, shaking their hand or something like that.
all right.
Unless, like I said, a body fluid is involved.
All right. What was the next item that you looked at?
All right, the next item was a sealed package containing a rock that was identified as collected from the scene. And that was item 22.
And what were your findings as to that rock?
Okay, well, the analyst saw a stain on the rock and tested it, and it was positive for, in the 2 tests that they used for screening for blood. And also took some contact swabbings, which again I'm assuming are from unstained areas of the rock, to try to find skin DNA for whoever was holding the rock. That would be the idea.
Move to strike
all of
any
that-
assumptions, Your Honor. Objection to her assumptions. If she's testifying from the lab notes, that's fine, but I object to any assumptions she might be making.
They're based on her review as provided. She's reviewing the materials and testifying as an expert based on her. She's giving her opinion as to.
I'm going to sustain the objection.
All right. Was there any Mr. Ibarra's DNA found on the rock?
No, so all of that DNA on item 22, which was the rock, all of that was a single source DNA profile that matched the profile of the victim.
All right. Next item. What was the next item that you reviewed?
This was item 23, which was also a rock, and they did the exact same thing with this rock. They swabbed a stain, and they also did what they called contact swabbings. And again, both of those came back single source DNA profile matching that of the victim.
Next item that you reviewed, Dr. Ballard?
This was item 24. It was described as a cutting from a tree. They tested that for blood using the 2 tests they used, and they were both positive. And then a swab was taken from that stain, and it came back single source sample, single source profile matching that of the victim.
Mr. Ibarra's DNA, was that found on the tree?
No, it was just DNA entirely from her.
What was the next item that you reviewed?
The next item was this was item 25. It was a sealed package containing clothing identified as coming from the victim. And that included 25A was a black jacket, 25B was a black shirt, and 25C was a piece of black bra. The laboratory did a couple of things with this. They used something called an alternative light source, which is also called a crime light. This is a narrow wavelength of light that is shined at an object and excites fluorescence in some materials. And there are biological fluids, particularly semen, saliva, and urine, that will respond to this light. And so she screened and found a bunch of stains on all of these items. However, lots and lots of things. It's a very non-specific screen, this ALS or crime light. It picks up a lot of different things. So it's not unusual to just look at somebody's shirt and find multiple stains with this thing. It doesn't mean they're body fluids. So appropriately, she followed up with a test for seminal fluid, is what she wanted to know, if there was any seminal fluid. Apparently that was her question. And so she did something called an acid phosphatase test, which is an enzyme found at high levels in semen. And all of that was negative on all the items. And so she didn't take any of those forward for any further testing.
Okay. So no additional tests.
Correct.
All right.
No DNA testing.
All right. What was the next item that you reviewed?
The next item was item 26, and that was a sealed package containing another piece of the bra. And again, she did the same techniques, the ALS, the alternative light source, and tested those stains, all those stains for seminal fluid, and it was negative using the acid phosphatase test, and so she didn't do any further testing on the bra either, on that piece of bra.
And the next item you looked at?
The next item was item 35. And that was a sealed package containing buccal or cheek cell swabs from the defendant that was used to establish his reference DNA profile.
Okay. So just the reference source, correct?
Correct.
And what was the next item that you looked at?
This would be item 39. It was a sealed package containing a black ball cap that was submitted to the lab for trace evidence, forensic biology, and latent prints. She did do serology on this. She tested 9 stains on this item, and she got a weak positive result for blood on one stain only. That was stain number 9. So she took that one forward for DNA testing, and again used true allele as an assistance, and got a DNA mixture with at least 3 contributors with a match to the victim, and then due to limited data, the rest of the profile could not be interpreted, and so we don't know who were the other 2 contributors.
And I'm going to come. What was the next item you looked at?
That was item 41. It was a who were the other 2 contributors.
And I'm going to come. What was the next item you looked at?
That was item 41. It was a who were the other 2 contributors.
And What was the next item you looked at?
That was item 41. It was a
15 minutes?
Judge. I was just going to say, Judge, I could get anything on Monday, so. For small favors.
Hey, take.
I can think about one thing at a time.
Madam Clerk, may we go back there? Yeah, well, it's up to,
There's something uniquely human about asking for a bathroom break in front of God and everybody. It's like, we can focus on your testimony right now.
Well, hey, that's.
Okay.
15 minutes. You need to look at or
No, I mean, I just trying to make sure I covered everything.
be curious.
Because she thinks she's got their quantification date over there.
I'm just curious how the next part's going to go.
I'm curious too, but I trust her.
We shall see. Here. Oh, sorry.
I think at the very least we've established. And I'll do that on read. Okay. Just write it out and I'll make sure. That's all. Now, what Sheila has, I'm done with the technology. We're just checking. You have to ask this Ross.
Depends on how quickly she answers, but at least 30 minutes.
And y'all, we need like presentation things.
Yeah, I'm gonna show her things.
Okay.
Just not presentation things, but I need the Elmo.
Okay, yeah.
Great, because she'll be able to see the Elmo, right?
She does. Yes, she does.
Yeah. I know. You know what? You're absolutely right. I need Santana. Santana. Maria. How much more time do we have? get the victims back in, I was going to say. Can we get the victims back in? The victims' family, can they all come back in, please?
Y'all have a seat. Right. You were finished with your direct, as I recall.
We are finished with our direct.
Ms. Ross, any questions?
I do have questions, Your Honor. I'm just wondering if we could wait one moment to allow the victim's family to return.
Oh, yeah.
I think they all went, and
It takes a while.
the facilities are a little crowded here today. I think they are en route, though.
Minutes in this setting is aspiration.
Yes, sir.
Back. I believe we're ready. Thank you, sir, for the patience.
Proceed.
Thank you. And I, with the court's permission, may I stay seated for cross-examination for the microphone? Thank you. Good afternoon, Dr. Ballard. Can you hear me?
I can.
Okay, great. Please just let me know at any time if you cannot hear me. First of all, I want to go back a little bit to where we started. Your 6-month sabbatical at the Sacramento County District Attorney's Office, did that qualify you under FBI QAS standards as a DNA analyst?
No, that's not what that was about.
Okay. Have you ever been qualified as a DNA analyst?
Not in the way that you're suggesting. So you're suggesting, working in a crime lab, doing evidence, all of that stuff. I've never worked in a crime lab in that way, no.
I want to talk to you a little bit about the timeline. So it appears to me, based on what I've been able to read, and please correct me if I'm wrong, you were formally retained on January 6th of 2026 by appellate counsel in this case. Is that right?
That sounds correct, yes.
On January 14th of 2026, you note in your report that the discovery was given to you. Is that correct?
Yes.
And I know that some of the discovery is what's contained in Defense Exhibit 4, which is predominantly the raw data from the GBI. But I noted, or you noted in your report, that you reviewed some other sources, correct?
I'm not sure what you mean.
Well, on page 3 of your report, you say you reviewed the map of the crime scene, States Exhibit 154. Did you do that?
Yes, I did.
Okay. Number 3, trial transcript, volume 1, page 257, the examination of Preston Norris. Did you review that?
Yes.
And then 4, selected police reports for information and background only. Did you review that?
Yes, to get the case background so I understood what the crime was what the crime was about. Yes.
All right. And then on January 29th of 2026, which was just yesterday, you produced a 6-page report. Is that correct?
Yes.
And between January 6th of 2026, when you were retained, and until yesterday, when you produced this report, how many hours did you spend?
Well, I didn't start spending any hours until I believe it was the 14th when I had a meeting with the attorneys. That's sometime.
Yeah.
But I didn't start really spending any time on it until I got the discovery.
All right. I don't care when you spent the time. I'm just trying to get a total time. Total time.
I would say by this time, I'm just looking, I keep a record of these kinds of things, so I'm looking at it, it's probably have been maybe 12 or 13 hours.
Okay. Now, I want to talk to you about your chart, which has been admitted as Defense Exhibit 8. And I heard you say that this was a chart of everything tested in this case. That was what you testified to on direct. Do you mean all the serology and DNA, or did you mean everything actually tested in this case?
No, my focus is just what the lab received for biology testing and the tests, the serology and DNA they did on that. I didn't look at latent prints. I didn't look at ballistics. I didn't look at any of the other things that could have been submitted as evidence.
So for that we're clear on the record, did you read any of the trace evidence reports produced by the Georgia Bureau of Investigation in this case?
No.
Did you read any fingerprint reports, either from GBI or from what is called the Athens-Clarke County Police Department? Did you read any fingerprint reports?
No.
And did you consider any of those things in forming the opinion that we heard you testify here today?
No.
Did you see any videos of the defendant wearing the Adidas hat that was tested for blood? Did you see those videos?
No.
Did you see any videos of the defendant carrying the blue jacket that you have discussed the testing on?
No.
Did you see any videos of the defendant discarding those bloody gloves that you have discussed?
No.
Okay. So you form your opinion based solely on the things that you've told us about already, correct?
Correct.
And you told us there are some things that you didn't have. And I noticed when reading over Defense Exhibit 8, you don't have the global filer data on the blue jacket and the gloves. And as a matter of fact, if you look at, if everybody can follow along, page 1, item 2, you first talk about the gloves, and you say in there, if I go down to the third line, you say 2B, black glove, and then you go all the way over, and in the end you say no further testing. Is that correct?
For the middle glove?
Yes, for 2B, you say no further testing.
Correct.
And going underneath that, for item 3, the jacket, item 20 is the cutting of the stain, which you've talked about. There was blood on the jacket, right?
Yeah, it was presumptively positive in those two tests.
And you write no further testing, correct?
Correct.
Would it surprise you to know that you are wrong about that?
Well, in my review, I did not see that testing reported.
Well, you had the opportunity to review the trial transcript, correct?
I have not reviewed the trial transcript except one thing on the trial transcript.
Okay, your DNA. Go ahead.
Yeah, so that, no, I have not looked at that yet.
Okay.
I have not done a complete review of this case yet. I don't have all the materials, and I have not had time to look at everything. So that's why I make a list of all of the things that I relied upon to come at my opinion at this time.
If you had read the trial transcript, Ashley Hinkle, the DNA analyst, testified in the trial. Would it surprise you to know that she testified at trial?
No, not at all.
And she testifies at trial to the results, global filer results. And just so we're clear, global filer means traditional DNA testing, right? We're not talking true allele, right?
Correct.
Okay. And that Ms. Hinkle testified to global filer results of both the gloves and the jacket, and that those results are that the blood on the jacket, or that stain, which was blood, went on to DNA. It's global filer results, and it's both Laken Riley and Jose Ibarra on that jacket. And I'm going to show you, and maybe they are also part of the record already, but let me just show you for the record. I'm going to have to move, right, Your Honor? Can you toggle over? Can you hear me now that I'm over here?
I can hear you. I can't really read that report, but I have a copy of it somewhere. What's the date on it?
Well, this report is dated February 29th of 2024, and it is, and I have had it marked for State's Exhibit 4 for the record, but it's already part of the record because it is attached to the Daubert transcript, Your Honor, which is November 1st of 2024. This is State's Exhibit 4, and so that everybody knows, it's already attached to the record. But have you read this report?
Okay, so I have a report dated 2/26/2024 that was a blood report. I'm just looking to see the first DNA report and what the date on that was. So just give me a second. The first DNA report that I reviewed was on, I believe, 3/14/24. Is that this one?
No, this is 2/29. So if you could look back at the screen, and just for the record, I'm going to go ahead and move to admit States 4 so that we can all follow along, but it is already, again, part of the record because it's part of the Daubert transcript.
Any objection to 4?
No objection. It's already been admitted in previous hearings.
Case 4 is admitted in this proceeding.
I'm showing you page 2 of 4 on State's Exhibit 4, which talks about the major profile obtained from the cutting of the blue jacket. Item 3 matches the profile of Laken Riley. The frequency in which the major profile, and it goes on. But those are global filer results. And you had not seen those prior to me showing you these today?
Correct. I don't have that report as far as I can tell.
And below that, there's also global filer results from the black glove on that same report. And you do not have that as well, correct?
Well, I have some global filer data on the gloves. So which one, specific one are you talking about?
Well, you can read it.
Is it 2B or 3B? I can't read it from there, honestly.
It's 2A.
Okay, 2A. Yes, I have that. That's in my report.
Okay.
It's in my spreadsheet as well.
The global filer results and the traditional trio allele results on the traditional DNA results on the gloves.
On glove A, on 2A.
Yes.
Yeah, I have that in my spreadsheet.
So you have that in your spreadsheet, but you do not, and you would agree with me, you do not have the global filer results of the jacket, the cutting from the jacket of the blood, which is both
Correct.
Laken, Riley, and Jose Ibarra.
Right, I have the contact swabbing that was taken, and that was also a mixture of the two of them.
Okay.
Yeah,
Okay.
so it doesn't surprise me, but I did have that from the contact swabbing.
Did you, for the record, read the November 1st, 2024 Daubert hearing that was done in this case on the DNA?
No.
I'm going to show you now, or do you have, let me just ask you this, do you have a crime lab report dated 3/14/2024?
I do.
And on that, is that safe for me to say that is the YSTR results of the fingernail clippings of Laken Riley, correct? Both left and right?
Yes, and also there's also some global filer testing on that as well.
And I did not see this in your report, and I want to know if you saw this on State's Exhibit 5. And again, State's Exhibit 5 is already part of the record because it's part of the Daubert. I would like to move to admit State's Exhibit 5, which is a crime lab report, which she has, just so we can be clear on the record.
Any objection, Mr.?
No objection. It's already part of the record in this case.
5's admitted.
Showing you page 2 of 3 on State's Exhibit 5, which is the YSTR haplotype results, right? You follow me there?
Yes.
Can
yes.
you see in the
yes,
highlighted? Okay. So in that report, it clearly states that Diego Ibarra, even though he is a male paternal relative of the defendant, was excluded as the donor of the DNA underneath Laken Riley's fingernails, correct?
Well, he was excluded. First of all, they did not include him in the Y haplotype, so I don't know whether he's just not related, and he thinks he is. My reading of it was that there were two people that could be included under the Y haplotype, and that was the other person of interest and the defendant. But then the other person of interest was eliminated in the global filer testing.
Yes. So Diego Ibarra was eliminated. Are you talking about Diego when you say the other person of interest? Because that's confusing.
No, I'm talking about I can't remember his name.
You're talking about Argenis, right?
Argenis. I'm going to write it down so that I remember.
Okay. Well, in the global filer data and in the true allele results, both Argenis and Diego were eliminated as the source of the DNA underneath Laken Riley's fingernails, correct?
Let me just look at it so I'm saying it correctly, okay? Yes, that is, let's see, I'm looking at that, hold on. Fingernail clippings, right hand, at least two contributors, and then DNA match to defendant and exclusion of both of those individuals.
I think I can go back to my seat for now, Judge, and I'll go back when I can because it's a little awkward. Right, so for both true allele and YSTR, Diego Ibarra was eliminated, correct?
Correct.
Okay. And in your data that you put, you say on this is Defense 8, the first page, item 18, the nails. You talk about the YSTR results, AI, which is presumably Argenis, and defendant, JAI, I guess that's Jose Antonio Ibarra, and male relatives and their paternal line. And then you cite the frequency. But what you don't say in that line is what is in the result on State's Exhibit 5 that I just showed you is that Diego Ibarra was eliminated as a donor on the YSTR, right?
Correct. They did not include him as that, so I'm assuming that his haplotype is different.
Well, if you read the trial
yes.
transcript, would it surprise you to know that the DNA analyst in this case testified that Diego Ibarra has a genetic mutation which excluded him in the YSTR results?
Okay, that seems reasonable.
Okay.
Yeah, that can happen sometimes.
All right.
Yes. They can be related, but then he has a unique mutation that was not carried by the rest of the family, and that can happen. It's rare, but it can happen.
Okay, so if I hear you correctly, and looking at the DNA results in this case, on the jacket, the blue jacket, Jose Ibarra and Laken Riley's DNA from contact swabs, it's on the jacket. You were not privy to the blood results, correct?
That is correct.
That under Laken Riley's right and left fingernails for the YSTR results, it is a Jose Ibarra, or it could be Argenis Ibarra, but we know it's not Diego Ibarra, correct?
Correct. Now that I understand he has mutation, I thought maybe he wasn't, actually related to the family in some way, which can happen also.
Okay.
But now I know it's mutation. Okay, fine. So under the left hand, he was also eliminated by YSTR testing.
Okay. So we have either Jose or Argenis's DNA under both her left and right fingernails, correct? Under YSTR.
Well, we have either them or somebody in their paternal line. Yes.
Correct.
Just to be very clear. Yes.
Well, that's the YSTR results. But then when you go to true allele, true allele could only get results from the right hand, correct?
That is correct.
And under Laken Riley's right fingernails, according to the true allele results, it is Jose Ibarra's DNA, correct?
Correct.
And both Argenis and Diego were excluded, correct?
Correct.
Okay. And I noticed that you did read Preston Norris's transcript at trial, and I'm wondering what that testimony did in order to form your opinion in this case.
I believe, if I'm remembering correctly, I believe it had to do with where a particular item is located.
Okay.
And if I remember correctly, it had to do with the foam cup and the straw.
Okay.
Because there was some confusion about where that was actually located with respect to the crime scene.
Okay.
That's what I'm remembering.
Okay. I want to talk to you about your conclusion first, because I heard you testify on direct about half of your conclusion, but I want to talk about the whole conclusion. And I'm not blaming you for that, by the way, Dr. Ballard. You did not question yourself. So please don't take that wrong. I'm looking at page 5, the bottom of your report. And it's the last bullet point. Are you with me?
I'm going to get there in just a second.
I'll wait till you get there.
Okay.
At the original trial, the prosecutor argued that the defendant's DNA got onto the items when he murdered the victim. You have to flip the page, page 6 at the top. The original trial defense team argued that it got there when he helped his brother, Diego, who they hypothesized was the real killer, move the body after the fact, and that the defendant was not involved in the murder. Your conclusion, tell me if I'm wrong, I'm going to read it verbatim. Both hypotheses are reasonable explanations for the crime lab, serology, and DNA findings, and I can come to no informed opinion at this time as to which scenario is more likely, correct?
Right, and I'm just talking about, what I'm talking about there is what the DNA, serology, and DNA evidence are telling us in the case. I'm not talking about anything else, just that.
You're not talking about his right thumbprint on Laken Riley's cell phone that was found 8 feet away from her body. You did not consider that in reaching this hypothesis.
That is outside my area of expertise, so no, I did not.
And you did not read the trace evidence report, so you did not consider the fact that on that blue jacket, there were 26 hairs from Laken that had been forcibly removed, according to Trace, and wrapped around a button on his jacket. Did you consider that?
No.
You already told us you did not see any of the videos, so I'm not going to go over that again. But let me ask you this. Did you see any photographs in this case?
I saw some photographs of the crime scene evidence at the crime lab.
Okay.
I have not looked at anything but I think an aerial view of the crime scene. I remember that photograph. But I didn't look at any autopsy photos. I didn't look at any other types of materials yet.
So I want to ask you, did you see any photographs that were taken by the GBI? And this would be a different GBI. It's the field office, not the crime lab people, and crime scene specialists, that were taken of the defendant the very next day after the murder where he had scratches on his body. Did you see those photographs?
I do recall seeing something like that. I'm not, that is outside of my area of expertise, whether those are scratches or not. I'd have to leave that to somebody who does wound analysis.
Okay.
So, but I remember seeing some photographs that were in the stuff that I had available to review.
Do you agree with me, Dr. Ballard, that, hypothetically speaking, a victim who is fighting off her attacker and scratches him, that could be a reason for that person's DNA underneath her fingernails, correct?
Correct.
That can happen, right?
Yes.
And that's real. The science supports that, correct?
Correct.
And you didn't look at the photographs, or did you look at the photographs and forming any of your opinions that you just told us about?
Which photographs?
Of the defendant's body the day after the murder.
I remember seeing some, but like I said, I'm not a person that can look at those types of wounds and come to any conclusions about them. So you'd have to get a wound expert to talk about whether those are scratch marks or what. Okay. I don't know.
Okay. And you told us also that you would need some quant data. And what do I mean by that? The quantitative data. Can you explain that for the record? You would need the quant data on the DNA to perhaps reach more meaningful conclusions, correct?
That's correct, yes.
And your testimony was that you did not see that data and the stuff that was provided to you on Defense Exhibit 4. Is that correct?
So, so for the reports, the first two DNA reports, and those were the ones dated, just for the record, I'm not going to worry about the male screening report. I don't care about that one. But the DNA report it was dated 3/14/24, and the DNA report for 5/16/24. I did not have the full quantitation data provided.
Okay.
I did have the full quantitation provided for the report that did the straw, which was on 8/26/24. And in none of them did I have an indication of the amount, the actual amount of DNA in microliters that the laboratory had from these samples immediately prior to the DNA quantitation step. And so I need all of that in order to do a full analysis.
Right, and the DNA quant data could be, well, I've looked through state, I had a little time this morning, we had a little delay, and so I had some time to go through Defense Exhibit 4 this morning while we were waiting. And would it surprise you to know that I found the quantitative data, at least on the fingernails, in Defense Exhibit 4 this morning?
I would.
Okay, let me show you something.
Please, I'd love to see it.
I'm going to go back to this microphone. And the quant data and the way that the files were presented on Defense 4, they were TIFFed files. Do you know what I mean by a TIFFed file?
Yes, it's an image file.
Okay, when you opened the image file, were you getting multiple pages of that image or just one?
Multiple.
Okay, so States Exhibit, what I'm going to go ahead and mark, and I'm going to go ahead and mark and move to admit States Exhibit 7, 8, 9, and 10 for the record.
Any objection?
I think it's already in evidence. It'd just be a demonstrative at this point.
7, 8, 9, and 10 are admitted.
Okay, this came from Defense 4. Do you see States 10? Can you read it?
I can sort of read it, and it's what I need. It
Right.
looks like exactly what I need if that's for items 42 and 43.
Right. What I've highlighted, is that the quantitative data that you were looking for?
Yes, it is. It is. I don't have it. So I don't know if it didn't download when the files came over, when I downloaded on my computer, or what happened, but I do not have it.
States Exhibit 9. I'll put my finger over there. You see where it says quantity? Or my finger, my pencil, pen.
And that's for items which? I'm sorry. 45 and 46. I think those were reference samples. What the ones I was interested in was, I believe, 42 and 43. Those were the fingernails.
Okay.
And then the jacket, which was, I have the quantitative data for the straw.
Okay. Yeah.
I got that. And the jacket, which was item, I believe, 8, that one was item 21. And you're telling me that they also did item 20, which I don't have, even in my spreadsheet, because I don't have that report. But I did not have the quantitation for data for that one either. And I looked at the multiple pages.
Okay. So if you had the quantitative data, that's what I want to move to. Is it your testimony that you can use the quantitative data to determine how or when DNA was deposited on a certain item?
I don't think when. Okay, I think that would be, I can't time it. What I can say is, let's say that under those fingernails, there was thousands of cells worth of DNA that could be attributed to the defendant. That to me is out of the range if he moved a body, okay? That's out of the range of, somehow getting there some other way through a different type of activity than scratching, right? On the other hand, if there's 8 cells worth of DNA on those fingernails, I have good papers that support the fact, research that supports the fact that DNA can get transferred under the fingernails of people. And actually, if you take people and you swab their fingernails, about 30% of them have DNA from unknown people under them.
Well,
So it's not, this transfer can happen. So that's what I'm saying. So that's why the quant data is important to me, because it tells me what world we're in. Are we in a world where there's a possible explanation that this could have happened due, say, moving the body, just one example, shaking somebody's hand, those kinds of activities? Or is this something that really can't be explained by that?
Okay.
And I'm absolutely open to both possibilities. I don't know which it is at this point, because I didn't have the quant data when I put my spreadsheet together. Now that if I can get a copy of it, I will incorporate that into my spreadsheet, and that will inform my decision further.
Okay. And your decision is made solely on serology and DNA results, correct?
Yes.
And you absolutely don't even consider trace evidence, fingerprint evidence, video evidence. You don't consider any of those things in forming your opinion.
No.
Okay. And you said there's papers on it. This is one I want to ask you. What is this type of analysis called? What is it referred to in your field where you use quant data and you try to attribute how it got there?
Yeah, so it's typically called TPPR.
Yeah.
So it's basically transfer, prevalence, persistence, and recovery.
Okay. And how many times have you testified in a court of law as to TPPR results?
Many times.
Okay. And had you had any Daubert hearings in those many times? Or I know you testified in California, Kelly Fry, you're familiar with that standard?
Yes.
Okay. So have you had
Yeah.
any hearings on that?
No, I have not had any hearings on that particular thing.
Okay. So your opinion on that went unchallenged?
I guess so, yes. I don't think it went challenged on, I've had other things that I've just out, but not that.
All right. I want to know what scientific, well, first of all, are your results peer reviewed?
Are my results for what?
But your conclusion in this case, was it peer reviewed?
No.
What is peer review?
Well, peer review is when you write an article for a journal and you've done research, and then other people review the research that you did and suggest things like, did you think to put this control in? Did you think to add this kind of sample? Blah, 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 blah. And then it goes through another, you go back and do some experiments in the lab, and then you come back and it goes out for another peer review. And eventually, hopefully enough people believe it and feel it was well done that it gets published.
Well,
that's what we call the peer review process.
Okay, sorry. That's in the academic standard. What I want to know is crime lab. So, for example, if you read the trial transcript in this case, the DNA analyst, Ashley Hinkle, who testified that her results in this case, that means every result that she reported, every DNA result from the nails to true allele to the global file or traditional DNA results on the jacket, all of her results were peer reviewed by another certified DNA analyst. That's what I'm talking about. Their work being checked by other professionals in the field.
Right,
But
and I'm
academia.
part of that. I am part of that peer review process.
Okay.
I am a peer reviewer for their work. That's what I'm doing here.
My question is, who's peer reviewing your work?
Peer reviewers don't get peer reviewed.
Okay.
I'm a peer reviewer. I didn't do the actual work myself.
So the answer to my question is no one peer reviewed this report
I
that
have-
I read.
I have people that go through my reports. I have people that look at my spreadsheets and make sure the calculations are correct when I do yield calculations and like that. I have that kind of thing. But in terms of my opinion, I'm coming to it as an expert, and I'm peer reviewing the work at the lab, and then I'm contextualizing it for the attorney. That's my job.
So you
I mean,
feel-
would my peer reviewer need to be peer reviewed also?
well,
I mean, I don't know when that process is supposed to start and stop.
okay. So you feel as an expert you don't need to be peer reviewed.
Well, I feel like my work needs to be checked to make sure it's accurate, but my opinion is my opinion. That's that from all my years of experience and keeping up with the literature in the field and everything else. And other experts might disagree with me, okay? They might not agree, and that's okay.
And what I want to ask you then, just based on the science, because we've already established you're looking at the DNA reports and the serology, and you formed the opinion that we've already talked about. Is there any peer-reviewed journals that approve the use of TPPR in forensic U.S. criminal cases?
So they're not the articles are not going to make that assessment. Okay, the articles, they do work in that area and they publish the article. These are peer-reviewed articles. There are over 2,000 of them now on this topic. Okay, that are out there in the literature, looking at it in various aspects. How does this DNA get transferred? All of those kinds of things. Okay, so experts like myself read that literature, stay up with it, and then use that literature where appropriate to come to court and make assessments.
I want to separate my questions up a little bit. I understand LOCAR and the theory of transfer, and that every contact has a trace. That's been around since the early 1900s or 1800s or something. He's French. I get it. But there is a difference between talking about DNA transfers, just that DNA can be transferred, and attaching the significance of saying exactly how it was transferred based on quantitative data. So my question for you is this. Peer-reviewed journals on drawing a conclusion on how DNA was put on a certain thing, like fingernails, based on quantitative data alone. Where is the peer-reviewed scientific journals that approve that practice?
Well, I don't know of any particular scientific review paper that looked at that, but what you do is you look at the scientific literature. For example, one paper I looked at in this case is called Prevalence and Persistence of Foreign DNA Beneath Fingernails, okay? You look at how much DNA did they find, okay? Was there foreign DNA under it? They looked at cases of different types of crimes, homicides included. And they also looked at, sampling people from the general population and looking at, how many people have foreign DNA in the fingernails, and they figure out where it's from. That's relevant to this case. And I'm not going to, I would be doing, in my opinion, I would be remiss in coming to court and not talking about these things. Okay? I would be remiss coming to court and saying, oh, they found thousands of cells worth of DNA under this victim's fingernails. Could have gotten there anyway. Throw up my hands, no opinion. Okay? I would be remiss because I wouldn't be telling the jury what they need to hear about evidence like that.
Who is SWIGDAM?
SWIGDAM is the scientific working group that is looking at recommendations to the forensics community regarding issues involving DNA evidence, including DNA mixtures.
Have you read the December 1st, 2025 report from SWIGDAM and their position statement on just what you're talking about here today, which is using quant values to determine how DNA got on something?
Did you provide that to the attorney beforehand?
I did. I provided it to him this morning.
And I did read it.
Okay.
I'm making sure that we're talking about the same document.
Yeah.
So what that document talked about is called formal activity level propositions. Okay? I did not do formal activity level propositions in this case.
Okay.
SWIGDAM does not have a position on what I did in this case, okay? There is a formal process that involves Bayesian networks, and I have gone to presentations on those, and I also think that experts that use those kinds of things at this point are stepping outside their area of expertise to provide probabilities of certain things happening, and those being prior probabilities to what is the case here. And then opining on how probable it would that this would happen or this would happen, and taking that into account when coming up with a specific probability, like it's 40 times more likely or 30 times more likely. I don't do that, and I don't feel comfortable going to court on that at all.
Okay, but
What I do,
go ahead.
okay, what I do is that I look at the relevant scientific literature, and I ask myself, is there a possible or reasonable alternative explanation for how that DNA might have gotten there? That's what I ask myself. I don't say it's 40 times more likely. I'm not taking into account anything else. I'm looking at it and going, based on what we know about DNA transfer, is that a possible or reasonable type of explanation, or is it impossible? Is it so unlikely that it's essentially impossible? And that's what I come to court and testify on. That is not a formal activity level proposition, and that's what that entire thing you sent to me was about.
Okay, well, I'm going to move to admit States Exhibit 6 at this point, which is the SWIGDAM position paper.
No objection.
6 is admitted.
If you could, Doctor, going to page 2 of that SWIGDAM working group paper.
Yeah, I've got to put my hands back on it. Yes.
Okay. I mean, we could read the whole thing. It's in evidence. I'm not going to read it all because I'm not going to waste the judge's time. He doesn't like us to read to him, but I have to read one thing to you. It says the overall effect of TPPR testimony. You see where I'm at?
Yes, I do at the top. Yeah.
All right. Which is what you said you call this, TPPR.
Mm-hmm.
May, when taken together with other evidence in the case, tend to make the positions of the parties more or less likely. The weight that a judge or jury gives to the DNA analyst TPPR testimony may be a deciding factor in the outcome of trial. And they go on to give a formal statement that says, formal ALR or TPPR in its present form is not suitable for use in the United States criminal justice system. Do you see that? And do you agree with that?
Well, yeah, I actually do, and I didn't do that.
But
That's
you
what I'm telling you.
did-
I did not do formal ALR in this case.
But you did just look at DNA and serology reports and just said, well, based on those things, both of these hypotheses are reasonable, right?
That's right. That's right. But that's not formal ALR. It's a completely different thing. If you look at the last page of this, it says, since analysts will continue to face questions related to TPPR, the SWGDAM chair will task an existing SWGDAM committee or working group with exploring alternatives to the formal ALR approach. So they're still working on this, okay? Right. There are analysts at labs that will not make any statement about what this data tells you about how it might have gotten there. I feel, I would say that there are a lot of people, a lot of experts who are in my camp who would say I would feel I was remiss if I didn't give the jury that information. There's over 2,000 papers on these types of things now. It's not like we don't have any data.
Okay.
So that's what I'm saying. This SWGDAM thing really doesn't have anything to do with what I did.
And is that because that the formal TPPR signs like a legit, a statistical probability, right? But you did not.
Well, yes, and it also uses Bayesian networks, and I did not. Okay. So it's taking into consideration a bunch of prior probabilities of something that can step outside what I feel when I've seen people perform this and show their process, steps outside of the area of the DNA expert or serology and DNA expert. They might be opining on something that is really not, you know, what percent of times when people are smoking marijuana in their backyard with other people, do they share it? They'll come up with a probability of that and take that into account in coming up with some probability of DNA. They don't have any basis for that. And so that when I've seen it done, I feel very uncomfortable with it.
Because that's not generally accepted in your relevant scientific community, correct?
What, formal ALR?
Yes.
It is accepted in Australia and New Zealand pretty widely.
Are we in Australia or New Zealand?
But here in the United States, there are some people doing it, okay? There's even training courses you can go through for this. Right. But I would say that, you know, SWGDAM, I agree with them. I come down on the side of this with SWGDAM. SWGDAM is not mandatory. It doesn't tell everybody what to do. It's a recommendation to the community. Some experts disagree with SWGDAM. So it's not, you know, it's like everybody says, oh, SWGDAM said it's got to be true. But on this particular issue, I can say not about necessarily as much about formal ALR, which is not done as much in the United States. It's pretty rare. But the type of thing that I'm doing is not that. Okay? It is coming in and saying, based on the literature, these types of things have been shown to happen and are reasonable for certain circumstances. And if you scratch someone, okay, and all of that, you know, if I saw lots and lots of DNA in the fingernails from a perpetrator or a suspect or whatever, I'm going to be weighing that differently. I'm probably going to say it's not reasonable to say that got there in an innocent way. Or in a way that's another hypothesis given by the other side. And if I didn't tell the jury that, I think it'd be remiss.
Did you look at the length of Laken Riley's fingernails?
No, I don't know what the length was.
Okay. And wouldn't it matter whether someone had long fingernails versus short fingernails in your transfer DNA theory? Isn't that a consideration?
It could be. I don't know of any papers that specifically address that.
Is that why you didn't look at them?
Look at what?
Her fingernails.
No, I didn't look at the fingernails because I didn't have any photographs of them. I just have a description of what the analyst did with those nails, which said she swabbed them, so I don't even know how she swabbed them.
And just so that I can go and research this a little more, then, what papers are you relying upon if you're not doing TPPR formally, because you're not getting a percentage or probability number out there, that supports your hypothesis in this case?
Well, I have a whole stack of ones that I rely on. Like I said, in this case, one of the main ones I relied on, because it's relevant to the particular issue of the fingernails in this case, is called Prevalence and Persistence of Foreign DNA Beneath Fingernails. And it's from Forensic Science International Genetics. I'm happy to provide the link or a copy to you, so your analyst can look at it too.
I'm sorry, is that the one that was footnoted in your report?
No,
No.
that's a different one, which
Okay.
is actually a very good review article by Van Oorschot regarding the transfer of DNA and the dynamics of that.
So am I wrong when I say that only one scientific journal is in your report, and it's that one that's dropped at footnote 1, correct?
The reason I put that one in is because it does a review. It's a review paper, and it references a lot of the papers that I also rely on.
Okay.
So rather than giving a list of 22 papers or something like that, I list a very good recent review article that goes through all of those things. And that's why you oftentimes do just the review article. But I rely on other papers as well in coming to these conclusions, and some of them are much more, they're quite well aligned with what is said to have happened. Like, you don't want to use DNA transfer papers that, if you're looking at fingernails, for example, that have nothing to do with fingernails. So you want to look at something relevant to the case at hand as close as you can get.
I appreciate that explanation, but the answer to my question is the only one in your report is the one that you dropped as footnote 1, correct?
Correct.
Okay.
I was just trying to tell you why.
Okay. I think that's all I have, Your Honor.
Just a few follow-ups. All right, Dr. Ballard, your job in this case was to review the raw data that was used to do this DNA comparison. Is that correct?
Well, I don't know raw data. I was to review the crime lab reports, the analyst bench notes, the electronic DNA file, which we often call raw data, and the true allele material.
Okay. And all materials you received in this case, did that come from that download?
Yes.
And this, did you download it directly from the GBI?
Yes, I did.
Okay. So everything, and you looked at everything that was provided in that download, is that correct?
That's correct. However, I will say that sometimes during downloads, in my experience, I've been doing this a long time, sometimes during downloads, particular files do not download. Oftentimes, it's because they have a very long path name. And so I have had things happen before where a particular file does not reach me. And because I'm downloading it from a server or whatever. That's why I oftentimes prefer to get everything on a thumb drive, because I typically don't have those problems. I can just go straight to the thumb drive and not have to download it. So I tried to go into this material without downloading, and I couldn't get in there. I had to download it in order to actually look at it.
So just so we're clear, these were zip files that you were opening, correct? Were they zip?
Correct.
All right. Now, in your role, you're not hired as, you're not an expert in fingerprints, correct?
Correct.
Or trace fiber, you're not an expert in fiber evidence or anything like that?
No.
So you don't look at things that are outside your expertise?
Correct. I figure you'll have other experts that'll come in and talk about those.
Okay. And so you're just when your opinions are just based solely on the evidence that you look, the DNA evidence that was provided or presented in this case, and the evidence that the crime lab looked at in this case.
Correct.
And you're looking at what tests they did and what they did to reach their results.
Correct.
All right. And you did not have an opportunity to have this conversation with trial counsel, correct? You did not have a chance to look at all this data and go through it with them.
No, I wish I had, because if I had had a chance to explain, look, this is what I'm missing, and then they said, well, actually it's here, and I went in and looked, no, it's not there. What happened during the download? That would have been great, because I would much prefer to testify to having seen everything. But I think it's clear now what it is that I don't have, and it looks like there's an entire report I don't have. So I want to get all of those materials now.
All right. If I could just have 1 minute, Judge. All right, that's all the questions I have.
Anything else, Ms. Ross?
No, Your Honor.
All right. Can the witness be excused?
She may be excused. Thank
Any
you.
objections, Ms. Ross?
No, Your Honor.
Dr. Ballard, you're excused.
Thank you. Have a good day.
Thank you, Dr. Bauer. Thank you, Dr. Bauer.
Any other evidence?
No other evidence, Judge. We rest.
The only thing, just to clear up the record, Your Honor, is that for State's Exhibits 7 through 10, I said it in my questioning, but I want to make it clear. During our unexpected and unanticipated break this morning, I had the time to go through Defense 4, which is the thumb drive that they say is the documents that she got. And the States 7, 8, 9, and 10 were printed by the state from Defense 4 today. So just so that is clear for the record.
Anything else on the DNA issue that you are here to talk about?
No other evidence on the DNA issue that we're here to talk about.
Okay. Do you want to go ahead and proceed on the other items that I think the other was the cell phone?
Judge, I think as we put in our brief, I think we mostly incorporate previous arguments. Your Honor heard that. We just put that in our motion for new trial just to preserve so there's not any issue of waiver. But I think that was litigated pre-trial by previous counsel, and we would just submit on that, Judge. We don't have anything additional at this time. We may address arguments, but I don't have any arguments today on that. We just, except for incorporating what was previously argued.
I need to tender States 6 through 10 to Madam Court Reporter before I walk off with them. And Your Honor, the state would only have argument as to their enumeration of error, and it won't even be that long, but it's their burden, so it's a weird position for me to be in when I don't have a burden. But I would like to be heard orally before briefing, and I know they're going to request briefing, so I don't know how the court wishes to proceed.
We'll talk about that, but I'm going to go ahead and give you an opportunity to give me a summation if you want to do that. If you're saying you don't want to do that, then we can talk about the other options.
If I could just have, Judge, if I could just have like 5 minutes, and, because we were going to submit, just, we were going to submit to a briefing schedule and submit our arguments in brief after having a chance to review the transcript of Dr. Ballard's testimony.
Let me tell you, I'm probably not going to be willing to wait until there's a transcript of Dr. Ballard's testimony. So I don't know if that's helpful or not. We can still have a conversation about briefing if you want to do that. But here's what I envision, is something like this. We come up with a date that I simply get briefs and proposed orders from both sides.
That's also
I'm
agreeable.
not looking to.
That's agreeable.
I'm not looking for response briefs after that or anything else. How's that sound?
I'm okay with that, Judge.
All right. So talk to me about time frame for you, Mr. Luttrell and Mr. Dowds.
We'd ask for 30 days, Judge.
Ms. Ross?
That means mine's due on the same day or a different day?
Same day.
The 30 days will be acceptable to the state, sir.
Would Your Honor prefer us to do it as in the form of a proposed order? I know some courts want it as a proposed order or brief, but I'll.
Two separate documents if you want to do it this way. One's a brief, and I don't know why they call it a brief, because I have this feeling that that's not what I'm going to get, but you can be guided by that. Both sides can be, because I'll remind you that I have lived this. I mean, this was not a jury trial. This is something that I've had. So anyway, but it's, for instance, argument dealing with the cell phones, a citing to the transcript page numbers would be helpful to me. I'm just trying to say what would be helpful to me. I'm just looking for a brief and then a separate proposed order if you want to give one.
Okay. That's fine.
Your proposed order would not be very long, probably.
March 2nd.
Would be my guess. But, and I'm just trying to say we don't need to get a situation where we're getting reply briefs and that sort of thing. Because it's fairly straightforward, I think. So, 30 days?
30 days.
All right. So that's the end of,
Technically, it's March 2nd because the way that February is short.
it is.
That,
What is,
March 1st is a Sunday.
so that works out.
is quite smart of the state. I would like to just hammer down a specific date. I guess
Why don't we say 5 p.m. March the 2nd? That's a Monday. And filing is, of course, that's fine, but I'm really more interested in sending me a copy electronically to my office.
yes, Your Honor.
Yes, Your Honor.
Through Ms. Parker, right, Your Honor?
Yes, you can put her on there, you can put me on there.
Does Mr. Wilson still work here, Your Honor?
He does not.
Is he retired, I believe?
He has. He has.
But he has not yet been replaced, I suppose.
He has not.
I just want to make sure that I'm giving the copies.
Sure, that's a fair question. Anything else we can take up or need to take up?
I don't believe so.
Not from Mr. Ibarra.
No, sir.
Judge, if we could just check, since we were on WebEx and we do have Madam Interpreter here, if there was any issues with the defendant hearing or seeing the WebEx and communicating with his counsel and interpreter today.
So if you would, my question to Mr. Ibarra, well, you can go ahead. You want the interpreter, if you will help him to determine if he's been able to hear.
Do we want to argue this shit?
that satisfy your question?
It does, sir.
Or Ms. Ross, I think it is actually Ms. Ross's question. All right, we're adjourned. Thank you.
Thank you.
Everybody keep your seats for 5 minutes.
When we're clear to move, SMU has to get out first. I have 4 and 5.
Yes, you did. Yes, you did.
I run off with evidence all the time.
You can. Maybe the rest of it, because if we marched out, her report is in 5. Okay, the flash drive was full, and then changed that to
Wait a second. Her report is what? The flash drive is 4. The flash drive is 4. Okay, what's her report? 5.
Okay, Todd, thank you. Yes, sir. Very welcome.
I'm sorry. Trial.
Mr. Luttrell.
And I'm gonna have a day.
Error.
Of the hours we had. She won't.
Would have been 73. She graduated. Oh, is that right?